Honourable Senators, I am now in receipt of the instrument, so the Senate shall resume.
Yes.
Received the following correspondence. I have to.
Announcements by the President.
Honourable Senators, I apologize. I'm just trying to save you some time. So I am in receipt of the following correspondence from His Excellency, the President. The Constitution of the Republic of Trinidad and Tobago by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Pastor Clive Dottin. Whereas Senator Torrell Shrikissoon is incapable of performing his duties as a senator by reason of illness, now therefore I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Pastor Clive Dottin, to be temporarily a member of the Senate with effect from the 4th of July 2017 and continuing during the absence by reason of illness of the said Senator Torrell Shrikissoon, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 4th day of July 2017. Honourable Senators, a Senator is required to take the oath.
I, Clive Dottin, having been appointed a member of Parliament, do affirm by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honourable Senators, we shall now resume into committee.
Clause 32.
Honourable Senators, the question is that clause 32 stand part of the bill. Honourable Senators, the question is that clause 32 now stand a part of the bill. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Clause 32 now stand part of the bill.
Clause 33.
Honourable Senators, the question is that Clause 33 stand part of the bill. Honourable Senators, the question is that Clause 33 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 33 now stands part of the bill.
Clause 34.
Honourable Senators, the question is that Clause 34 stand part of the bill. Senator Ramdeen, you had circulated an amendment, a proposed amendment to Clause 34.
Would you just allow me 1 minute, Madam President?
Honourable Attorney General, you have also proposed an amendment.
Yes, please, ma'am.
You want to go first?
Yes, please.
Sure.
Madam Chair, we ended on the last occasion, but I had the benefit of receiving submissions from Senator Ramdeen in writing as to Clause 34. The proposal offered by the opposition was that there should be a certain type of process for the court sealing the record. And then it essentially ended with criminalization for an improper disclosure. That, in a nutshell, was the theory behind the amendments, which I can understand quite clearly. There is merit in that persuasion. The government had the opportunity to consider it. Regrettably, at this stage, we don't join in the recommendation that there should be a criminalization for a breach of a disclosure order in the terms recommended by the opposition, but we certainly have no objection with the provision of reasons for the provision of the sealing of a record as proposed by Clause 34. So we propose to accept the recommendation of the opposition that we do provide reasons for the sealing of records, but we respectfully are not in a position to agree with the criminalization or for the more prescriptive approach for the sealing of records as recommended in the draft circulated by the opposition.
Senator Choate.
Madam Chairman, thank you. Honourable AG, I have a question. If it is that there has been some sort of impropriety between the parties which resulted in a plea agreement, it's not outside the realm of possibility that a court may have known about it. If these records are sealed, how is that impropriety going to be addressed?
Good question. I suppose the immediate frank response to that is that there is no guarantee that it can be addressed in any one of the circumstances. The proposal in Clause 34, as stated, is that there must be an application by either party, subject to the court's discretion, that the records of plea discussions or agreements be sealed. So you're quite correct. It doesn't have to go as far as a pre-agreement. It could very well just be a discussion. Because this thing is subject to court's A, consideration of an application, B, exercise of its discretion, there is at least a process through that. They are actually in open court and not in camera unless an application is made for the proceedings to be in camera. But we thought that the recommendation coming from Senator Ramdeen was useful in this regard because the court would be bound to actually put reasons for the sealing of the records, which would then allow for some degree of other inspection or agitation. So I couldn't answer the question squarely to say that there would be a guarantee in some way or fashion that the mischief of something could be cloaked under an order for the sealing of records. But there is generally the need to provide for the sealing of records for the other side of the equation, where it would be in the administration, in the interest of the administration of justice, or in the interest of justice per se, that records be sealed, for instance, as it relates to witnesses or certain other aspects which may impact upon other matters before the court. So I know that I haven't answered your question, but hopefully I've explained why.
Madam Chairman, if I may, it seems to me that if we go with this clause 34 as it is, then we are placing a hamstring, we're cutting the hamstring of the legislation, because we are saying that there are all these provisions to deal with the situation where people use the system improperly. But we are closing the door to investigation of that. So what will be the point of all of those clauses?
But A, it's within the court's discretion at any point in time whether the legislation says so or not to seal a record. But B, isn't it always subject to also to the exercise of a right of appeal in respect of the sealing of a record, whether it is rejected or not, or a review? And by appeal, I mean there certainly is an ability to have a sealing of a record reviewed at any point in time. The order continues unless otherwise varied, but there certainly is room for the variation.
Well, can I, in responding to that, just pose a scenario? If this person whose records are sealed is a witness against other persons, when their trial comes up, who are they going to appeal to? When their trial comes up, they have, at the trial, a right to cross-examine the person. At common law, they have a right to see all utterances made by this person, all statements made by this person, and all discussions or agreements made which led to either a conditional immunity or an absolute immunity. That's a common law. If we are to leave this clause as is, then, and the records are sealed, when these persons are on trial, how are they to know what was said during plea discussions by this accomplice well-known? What was said in terms of the agreement? How are they to cross-examine on the terms of the agreement or anything that may have been said in the plea discussions if both the discussions and the agreement is sealed? It would mean, therefore, that they lose the right to cross-examine, and that has implications in terms of the fairness of the trial. And two, the rights that they are normally entitled to under Section 6 and 7 of the Evidence Act, which is to compare what he may have said in the plea agreement or discussions with what he is saying now in court and make out a previous inconsistent statement.
Sure.
So that if the discussions and the agreement remain sealed as envisaged by Section 34, then this may undermine the ability of persons to have a fair trial.
Wouldn't the, Madam Chair, wouldn't the Evidence Act itself allow, I can't remember the section, is it Section 15? And isn't it also too in relation to the issue of character that applications can be made?
Characters, yes, I understand what you're saying, Attorney General, but character would relate to, yes, you would have to disclose whether this person has previous convictions or pending matters, and an application can be made to the trial judge to determine whether he or she would admit evidence of the bad character of this witness. But that's quite apart from what this witness may have said during the course of plea discussions or in the terms agreed to in the plea agreement. And that is the part that would frustrate or stymie the ability of counsel for the accused persons who are on trial to cross-examine under Section 7.
Can't it also be met by the request to subpoena the record, be met by the obstacle of it having been sealed, and then ask for the unsealing of the record, have the reasons produced, and then to make submissions on the ability to achieve or not achieve the purpose?
Well, the difficulty is, Attorney General, is that's not clear from the from Section 34 unless that is expressed as a possibility open. That's one. And two, if one court has already made a decision to seal, then another court of equal jurisdiction cannot simply unseal unless there's a power to unseal. So, because they are of equal jurisdiction, one court is not a court of appeal for the other. So that the only way this can work is if we take out the requirement of sealing, or if we put in specific provisions to deal with scenarios where there's an application. Well, it shouldn't even be based on an application. The common law itself means that we are entitled to everything that was said, either during the discussions or agreement, as a statement made by this accomplice well known. We are entitled to it as of right. So if we are entitled to it as of right, by the very provisions of clause 34, it means you are going to take away these rights at common law.
Okay, before you reply, Attorney General, Senator Roach indicated you wanted to say something.
Thank you, Madam Chair. Notwithstanding what my learned colleagues have said, I think the court has an inherent jurisdiction all the time to unseal documents if need be, if it's in the interest of justice. So it's not necessary that another court is at the same level, is acting as a court of appeal, basically. But the court has an inherent jurisdiction to unseal documents if need be. It goes on in matrimonial matters, it goes on in a number of matters, as the case may be.
That's as I understand it precisely, that the inherent and/or implied and/or express provisions in other laws still prevail. All that we're providing for in this 34 is the fact that the court can actually seal a record, and it's done specifically so that persons who may otherwise be dissuaded from participating in these positions know that there is a positive right that they can ask to be exercised and considered, not guaranteed, by the court of record which is considering this point. So I didn't see that anything was in the way of another court entertaining an application under Section 15 of the Evidence Act, or an application suitably posited for bad character, or an application for the unsealing of a record of its own volition, or for the court to be invited to consider the evidence in a particular way in light of a refusal for the disclosure or subpoena to be honored.
Well, can I just
Senator Sturge, I was going to recognize Senator Choate, who had indicated she wanted to speak.
Thank you, Madam Chairman. The more I look at this clause 34, it seems to me that this really can be a rogue's charter, because it says a court may, upon application by either party. So if you have an accused person, let's say, who has concealed something, or who has come about a plea bargain in some sort of improper way, then all he needs to do is make an application to the court for the records to be sealed, for the proceedings to be sealed. Then it would mean that he would benefit, he'd be able to cover his tracks both from the prosecutor and from the judge. And there is no safeguard contained in this section to allow for that. So I understand why you would want to have records sealed in certain circumstances, but I respectfully disagree with my friend Senator Roach. I don't think that the inherent jurisdiction of any court is going to be able to address that. In any event, magistrates' courts don't have inherent jurisdiction. So perhaps you can change it around and say that a court in exceptional circumstances, perhaps, because justice is supposed to be as transparent as possible. So if we say in exceptional circumstances and the judge then has to give reasons, at least we have some protection against persons who would want to use this clause for purposes that it was not intended to be used for.
Senator Ramdeen asked, then Senator Solomon, Senator Sturge. Senator Ramdeen, Senator Solomon, Senator Sturge, then the Attorney General. Senator Roach, and then the Attorney General.
Madam Chair, through you to the Attorney General. Attorney General, the reason, first of all, thank you for accepting the amendment as proposed with respect to the written reasons. The difficulty that I have with the clause as is that it is the court which, in the case of the High Court, would be a court of superior record, which will not be subject to judicial review because it is a superior court of record. So I would have proposed that if we were going to keep, as a matter of policy, the idea of sealing records, then what we should do is perhaps remove the court and let it be the registrar, so that that decision can be subject to judicial review. If the registrar makes a decision, you can challenge it. There's no purpose served by having a provision for the provision of reasons if those reasons are not going to inform either party or provide that party with an avenue by which you can challenge those reasons, because you're not just going to impose the ability to give, or the duty, sorry, to give reasons in a vacuum. Providing reasons and the court not having, or the parties not having an opportunity to challenge that as a safeguard or to test the correctness of that decision to seal those documents is going to be serving absolutely no purpose. I would have suggested, in accordance with what Senator Choate had said about the inherent jurisdiction, and I come back to the point that I'm not sure that if we provide by statute for these things to be done, that the inherent jurisdiction will still survive. That we say the registrar, in the case of the High Court, or the clerk of the peace, in the case of a summary court. Well, we don't have to say the clerk of the peace because summary court will be subject to judicial review anyway, I'm sorry. So we say the registrar, which is the procedure that it is now. It is the registrar that you make the application to, unless you are before the court and the court wants to exercise that power to seal the documents. But you are very familiar with the fact that you make applications to the registrar in all of these matters to seal the records. So why not give that opportunity to either party? If they want to challenge it, to remove it, if there's some third party who is affected by it, they can make an application. If that application is turned down, they can judicially review the registrar. So at least we have some form of protection. But that is the only way that I can suggest in keeping the clause as a matter of policy, but providing some kind of protection to a party who wishes to challenge it.
Senator Solomon.
Much obliged, Madam Chair. Through you to the Honorable Attorney General, I think that this entire matter of sealing documents and these plea agreements being private and done in dark rooms and between parties and not being made public is a serious affront to justice. I think that justice must not only be done, it must be seen to be done as a principle and as a policy decision. I think that if it is that the Attorney General is going to insist on this clause in its entirety, then I will echo what the Honorable Sophia Choate has said and make sure that those exceptional circumstances are properly articulated and that the protections of the evidential issues are also addressed, because those are major issues for persons down the line who will be faced with a situation where certain other persons may have entered into plea agreements to save their own skin, and the evidence would already be tenuous at best and would be used to convict other persons and not be challenged and have the benefit of this seal, which would keep it in the darkness that it doesn't deserve to be, in my humble opinion. The issue of if I may, Madam Chair, the issue of jurisdictions are a major issue in this country. There are often overlaps between the High Court, the Family Court, the Industrial Court, and judges are very loath to interfere with one another's jurisdictions. So I think that we need to give proper consideration and thought as to this entire concept, how we're going to implement it, how it's going to affect the justice in other matters, and how it's going to affect your jurisdictions.
Senator Sturge.
Madam Chair, through you, there are three issues I wish to raise that I haven't touched upon, and I would seek to to piggyback on what my friends have said. Firstly, as it stands, if the DPP is proceeding under common law, nothing is sealed. So if the DPP is proceeding under common law and not under this act, then at common law he has to disclose all utterances made by this person, this accomplice well known, all if it's videotaped, the videotaped interviews, the discussions, the agreements, everything that has been said by this person has to be made available as part of the package together with, you always get the package with a copy of the immunity given, whether it's conditional immunity or absolute immunity. But attached to the absolute and the conditional immunity would be not only the statement where there's an agreement and he's giving evidence in accordance with these immunities given, but every other statement given before that, whether they are consistent or inconsistent, the defense is entitled to it as of right. It is not subject to the discretion of the prosecutor as to whether it is given or not. So if that is the case, where at common law we are entitled as of right to all of these statements and utterances and interviews, all of the material, everything surrounding the history leading up to the granting of the either conditional or absolute immunity, then why are we in a worse position if the DPP decides that he's not going at common law, but he's proceeding by way of the statute? That cannot be right. That's the first thing. The second thing is, for the defense counsel to meet the allegations being made by this accomplice well-known, and to make an application to a subsequent court, as suggested by Senator Roach, he would first have to know of the existence of this plea agreement and the discussions and so on, or else he's shooting in the dark. So that if he does not know, and therefore he does not ask, and the prosecutor does not say, then there's a possibility of a serious miscarriage of justice, because the terms and conditions and all the previous inconsistent statements or consistent statements or whichever, which are normally given as a matter of right, would not be available so that the accused persons can defend themselves, and that must be wrong. Lastly, whether even if the prosecutor, the prosecutor wants to act fairly, the prosecutor, once he proceeds under this act, he doesn't have the ability to, once these records are sealed, he has no discretion or power to divulge the discussions or interviews or agreements or utterances of this accomplice well-known to the defense. Under common law, you are entitled to it and the prosecutor must give it. Under this section, it is quite clear that the prosecutor's hands are tied. So that in itself cannot be right, because the prosecutor, acting as a minister of justice, must be able, in the interest of justice, to provide these agreements, discussions, and so on, to ensure that a fair trial takes place.
Senator Roach.
Chair. I heard what my learned friends have said here, but be as it may, is it that we are getting difficulty with the fact that the record is to be sealed per se, and they're saying that it ought not to be sealed? Is this where we are now? Because I'm looking at the section inside. We talk about the court. You're giving the court may. It's not saying that it's not shall. It's the court may. The court has a discretion, and the court, in any instance, in the making a determination, the court is not going to be frivolously or easily persuaded to do something as significant as sealing a document. Whenever a document a case is to be sealed, it's a very serious discussion on the part of the court in determining whether or not it ought to be sealed or not. And it is very rare circumstances, and a lot goes into making a determination whether it be sealed. So is it that we are not trusting the discretion of the court in this instance to deal with something as this? Or is it we saying it's safer to not have the document, the plea bargain seal at all, and take out seal of it? If not, there is a discretion here for the court to deal with, which is always exercised.
Senator Choate. All right, members. Senator Choate, but at some point in time I have to ask the AG to respond, and at some point in time the discussions will have to end with a decision being made. Okay? Senator Choate.
Madam Chairman, thank you. I'll try to be as brief as possible. The concern I have about the sealing of records in criminal proceedings as opposed to any other kind of proceedings is because I have witnessed the injustice which may flow from the sealing of a record. I will give an example of a case in which I had been involved in where there was an issue of jury tampering. An inquiry was held by the trial judge, and there was sufficient material to suggest that that had in fact occurred. Now, instead of the matter being sent for further investigation to the police, the prosecutor in that matter asked that the records be sealed, and so they were. And as such, nothing came out of it. So I just want to bring that to your attention to show that serious criminality can be covered up by an order of this kind.
Yes.
My only fear in allowing the arguments to, well, the propositions to go is that it's very difficult to then keep the thread of response, Madam Chair. So without truncating, may I just be permitted to answer a few, because the longer the line gets, the more the assumptions of submissions go. So may I please interject?
Yes.
Thank you, please. First of all, I wish to thank all honourable senators for these submissions. I understand the concerns raised, which are genuine concerns, and certainly I rely upon the practitioners in the criminal arena for their own experience. That in the civil arena is somewhat different. I'll try my best to respond as follows. Well, I do find it very attractive to include the qualifier of in exceptional circumstances. It would allow the court to have circumspection in the exercise of its discretion to actually seal records. Doesn't remove or fetter unduly, I think, the court's exercise in its own manner and accord to consider those circumstances. In any event, I think it accords with when records are sealed in any event. Records are hardly ever sealed for other than good reason. So I think that we'd be doing well to qualify it that way. It sort of ties in with Senator Solomon's reflections that there may be dark rooms or recesses, and that justice must not only be done but seen to be done. And therefore it can assist us with the submission made by Senator Solomon. Senator Ramdeen noted the circumstance where the application could be made and reflected upon the fact that the accused may make an application and therefore deal with the covering up of serious evidence of criminality, which Senator Choate has given us a personal reflection upon. But I bear in mind that the application by either party is one to be made before by both parties being informed. The application is not an ex parte application. It will always be an inter partes application. I found it a very novel and interesting perspective to consider the registrar as the officer, specifically to allow for the application of judicial review principles. I agree that the court of inferior record, the court not of superior record, the summary court, isn't bound by the limitations of being a court of record, of superior record, and therefore is reviewable. My fear in prescribing that the registrar should be the person to do the sealing is that you are going to automatically refer the matter away from the sitting judge. Now, it's true that a judge can exercise all the functions of the court, including that of a registrar. But when statute steps out of its way to say that the registrar should consider the factor for the stated purpose of being a reviewable matter, because the registrar would be reviewable, it's to invite an application where the judge seized of the matter and aware of all the circumstances, passes over the matter to a registrar who is not only not as experienced as the sitting judge is, but who is not blessed with the experience of having heard the entire matter of the plea hearing in its continuity. From that purpose, I would resist the urge to move to the registrar. In any event, A, the matter being inter partes, B, the judge having heard the whole of the plea agreement, C, the judge is always reviewable. and the judge is reviewable by the Court of Appeal. So there is a check and balance to that process in the sealing of the record. In the position of the 3 points proposed by Senator Sturge, firstly, that relating to the common law. Secondly, the obligation to disclose, in that the common law requires that the prosecutor must disclose the evidence. And thirdly, the observation that the prosecutor would be hamstrung and have no power to reveal discussions. It can't be, and this is my own understanding of the situation, that the fact that a record is sealed is a bar to saying that there is a record, but it is sealed. What the prosecutor who had sealed the record would be constrained by is divulging the contents of what has been sealed, not the fact that there was something. There would always be, at the common law, preserved the obligation on the part of the prosecutor to say X and Y exists or may have arisen in a matter, but that matter is sealed. And that therefore raises the specter of whether there has been full disclosure or not. In all of the circumstances, taking the submissions forward, I would therefore, as novel, and I mean that in a complementary way, as the registrar's approach may be, I'd prefer to keep it as the court, having heard the plea agreement, comforted by the process of the ability to have it reviewed upon appeal. I would agree that we consider the insertion of the concept of in exceptional circumstances, because it would prescribe the caution which the court should exercise in relation to this matter. I still think that a court of lateral jurisdiction, a court of first instance, would hardly be minded to follow, to move against another court of first instance, or worse yet, a court of inferior record, the magistrate's court, the summary court, would have a difficulty with a court of superior record having sealed a matter, but that still allows and doesn't prescribe against an application for the production of it in the manner in which I've suggested, which is A, at the common law, albeit walking up to the wall of saying I can't go further, B, of the application of the Evidence Act, Section 15 in particular, C, the application of the rules and procedures by which you get to bad character admission of evidence, and D, certainly for any other application that would exist as an inherent function of the court. So, Madam Chair, I propose that Clause 34 in those circumstances be amended by inserting after the word may the words in exceptional circumstances in the first line of Clause 34.
Just a second, please. Senator Mahabir wanted to ask something.
Yeah, I needed clarification, Madam Chair, from the Honorable Attorney General, because when I look at what he had proposed earlier in Clause 4, and he then withdrew for the good administration of justice, and he kept in the interest of justice, I see in an important matter as the sealing of records, he is keeping in the interest of the effective administration of justice. I would have thought that in this, something as important as the sealing of a record, you would want to have the jurisdiction as broad in the interest of justice, because from where I sit, the effective administration is procedural, but justice is broad. Justice may in fact overwhelm the procedural matters, and it may involve protecting witnesses, it may involve protecting victims, so that I simply need clarification from you as to why you withdrew for the good administration of justice in Clause 4, but you are not keeping in consistency with the architecture of the law that we still simply say in the interest of justice in this particular clause.
Madam Chair, I think that's a very excellent observation. Senator Mahabir is making us lawyers look bad today. No, I'm apart from being...
bribing me.
Apart from sweetening the pot, Madam Chair, I think it's a good observation in all sincerity, and we can perhaps attend to the language by keeping it to the interest of justice.
Senator Mark, you wanted to raise an issue?
Yeah, Madam Chair, I understand what the Attorney General is attempting to do in terms of incorporating what Senator Choate has submitted. But in the interest of justice, I wanted to ask him what is preventing the need for us to incorporate language that would generate full disclosure to the defense in a situation where there could be irregularities in the system and innocent individuals can be affected by this Section 34 that we are proposing. And therefore, I would ask him to reconsider his position on the matter of simply incorporating exceptional circumstances, which, as I said, I understand what he's attempting to do. But why not allow full disclosure in matters like those that are before the court, Madam Chair? So it is a concern that we have, and on principle, I am concerned, Madam Chair, about this incursion. I have seen it for the first time some time ago where some things were sealed, and I said, but this is looking like a secret society. I think that, for instance, we live in a democracy.
Okay, Senator
There
Mark.
should be full transparency. There should be full disclosure. And therefore, I'm asking the Attorney General to reconsider this clause 34 and allow full disclosure.
Madam Chair.
Before, no, Attorney General, Senator Sturge, one final comment? Senator Sturge.
Yes, Madam Chair, I just wanted some clarification from the Attorney General. The Attorney General said that one of the one way of redress for clause 34 would be for an appeal. But when I look at clause 34, the parties to clause 34 would be the party who is asking the accomplice well known, or the DPP asking the court to seal this agreement. So how does someone who is now on trial and has to answer the allegations made by the accomplice well known, where does he get the locus standi to appeal?
In those proceedings, I understand.
Yes,
Sure.
that's one. And I am wondering if the Attorney General has factored into the mix the fact that at present, at common law, the judge in a trial where there is accomplice well known has no power or jurisdiction to seal any record of what may have transpired with respect to that accomplice well known. Those are my two issues.
Attorney General.
Madam Chair, in answer to Senator Mark, if I accept Senator Mark's submission or considerations that there be full disclosure, what's to prevent us from requiring full disclosure? To do that would be to interfere with current judicial capacity where every judge has the right to seal proceedings, full stop. Senator Cho just gave us a live example in the common law where you can actually seal proceedings. So to provide a statutory prescription to say that all records shall never be sealed so that there can be full disclosure would be to interfere with the separation of powers principle and to impose upon the judiciary an outcome for a matter for which it should have its own discretion. That's to answer it in its most pointed of forms and fashion. So the reason for providing for that which exists already in common law, subject to what Senator Sturge has just said, which I'll come to in a moment, is to allow for the judicial exercise to be put in on a discretionary basis, as we now propose, in a fettered way for exceptional circumstances in the interest of justice. Senator Sturge has raised two very important points. Firstly, the locus of appeal, and secondly, the fact that there is no manner in which a person in the well-known category can seal or sequester evidence away from somebody who requires that evidence. Relative to the locus to appeal, Senator Sturge is of course perfectly correct. The person in other proceedings who is neither of the two parties, that is the prosecutor or the person in the capacity of well-known, obviously does not have the locus for an appeal on the record of sealing. However, that person has, in the other court that that person is before, a right to subpoena the records or call for the records once met with the opposition of a prosecutor saying there is a record but it is sealed. There's nothing to stop that person from making an application to that court to have the records subpoenaed. And I couldn't see, or produced, and I couldn't see what there is in that court itself, that is the lateral court, to prevent the court from considering whether that matter should be opened or not in the interest of justice, and that there are other routes and remedies to get there. The other point raised by Senator Sturge, which is that, and I'll take it this way, that the common law right now is that there is no way that these kinds of records for vel-nons can be blocked, full stop. I am not in a position of certainty as to that, not that I doubt what Senator Sturge tells me. I'm not a practitioner in that area of the law, and I'm not aware of that being the position. But I would imagine that there is always the ability, subject to the evolution of the common law in the courts, for that matter to be treated with. What we're providing here is, in my view, a need for the court to consider whether records should be sealed or not. That's not exceptional or out with the court's current jurisdiction. Secondly, I think that we are improved by the circumscribing of the clause, by the inclusion of in exceptional circumstances, and also by the use of the interest of justice formula. I don't think that I can move much further beyond that position. I'm, of course, still minded to hear further amplifications, if you permit it, Madam Chair, but the amendments that we propose beyond inclusion after the word may of the words in exceptional circumstances would be the deletion of the words appearing in the last line after the word interest, delete the words of the effective administration, so that it would read sealing of the records is in the interest of justice.
Madam Chair, if I may indulge you again. If what I just heard correctly from the mouths of the Attorney General, the lips, I should say, if this already exists, Madam Chair, within the jurisdiction of the judges in the courts, why do we want to incorporate this particular provision? It's already there. They already have that discretion. You see, Madam Chair.
I think, Attorney General, would you like to answer that?
Yes, Madam Chair, that's true for almost every other clause in the bill. The point is to put milestones down for judicial understanding, because when the law is going to be interpreted as a whole, each section is going to be read against the whole of the law as a rule of statutory interpretation. And therefore, it is important in the mind of the court to have certain milestones, whether they are expressed or implied, put along the way of the legislative prescription.
Madam Chair, may I say finally, because I wouldn't disturb you again. It is our view that this provision is a very dangerous provision. We believe that this provision is very oppressive. And we also feel that this provision can be used to induce people to do certain things that could be very detrimental to their well-being, and it would be an affront to justice. And therefore, I serve notice that this section 34 is not acceptable to our side, and we'll ask the Attorney General once again to reconsider this provision, Madam Chair. I close my case on this matter.
I don't think there can be much more to be said in respect, unless you're going to add something that is completely different, Senator Solomon.
If I may, Madam Chair.
Sure.
Attorney General, I'm just wondering if you've consulted with DPP on this, because it seems to me as though we're running into a real risk of fettering with the judge's discretion. I mean, I could see situations where similar fact evidence could come into play, and the rights of an accused can be seriously hampered by this section. Perhaps it's ironic that it's section 34, but in any event, through you, Madam Chair, it is a very dangerous proposition, and I think that I would urge strongly that the Attorney General hold on this for the time being. Perhaps we can reflect and come back to it, given the wide ramifications and so I repeat my question through you, Madam Chair. Has the DPP been consulted on this?
Attorney General.
Sorry, Madam Chair, there was just a small emergency, I apologize. To answer the question posed by my learned colleague, we did request submissions from the Office of the DPP and did so on many occasions. And we have not received any negative response from the Office of the DPP. We've had some discussions, but we haven't had any pointed response to schedules. And we do communicate on a regular basis. I've received submissions on other material, but not on this. We did have very strong advocacy for the inclusion of this clause from the drafter of the bill, which is Mrs. Elder, as to the need to include this position. And again, this did arise out of the policy considerations beginning in the 2014 workshop, etc. I do note for the record Senator Mark's submission, which I understand. I don't respectfully agree with the position. I think that there are adequate safeguards in balance to those observations made by the Honourable Senator, but I simply agree to disagree at this point on that point.
May I just put on the record, Madam Chair? This is about the fifth or sixth time we are being told that the drafter, one Pamela Elder, has put this into the legislation. Mrs. Pamela Elder, with the greatest of respect, does not make law in this parliament.
Okay, well, but
So what I'm saying is that to tell us.
no, Senator Mark, I think your comments are noted. I think it is time that we bring the discussion on this particular clause to an end. And first of all, Senator Ramdeen, you are proceeding with your amendment, so I shall put your amendment to the committee.
I
Yes?
am, yes.
All right. So, Honourable Senators, the question is that Clause 34 be amended as circulated on behalf of Senator Ramdeen. Those in favour say aye.
Aye.
Those against say no.
No.
The amendment is not accepted. Honourable Senators, the question is that Clause 34, Clause 34 be amended as circulated by the Attorney General and further amended as follows. And please allow me to read what I have taken as the proposed amendment. Where has it gone? A court may, in exceptional circumstances, upon application by either party or in its discretion, order that the records of plea discussions or a plea agreement be sealed if the court is satisfied that the sealing of the records is in the interest of justice, and the court shall give written reasons for the order. Those in favor say aye. Aye. Those against say no.
No. You want a division?
Mr. Khan,
Yes.
Ms. Skopiskun,
Yes?
Mrs. Batiste Primus,
Yes.
Mr. Rambarat,
Yes.
Yes.
Sinanan, Mr. Hussain,
Ask first. Ask, yes.
Ms. West, Dr. Henry,
Yes.
Mr. Singh,
Yes.
Mr. Coppin,
Yes.
Mr. Cummins, Mr. De Freitas,
Yes.
Ms. Bash,
Yes.
Mr. Duque,
Yes.
Ms. Romano,
Yes.
Senator Mark,
No.
Mr. Solomon,
No.
Ms. Amin, Mr. Sturge,
No.
Mr. Samuel, Mr. Ramdeen,
No.
Dr. Mahabir,
Yes.
Mr. Roach,
Yes.
Senior Counsel Choate,
Yes.
Ms. Raful,
Yes.
Mr. Richards,
Yes.
Pastor Dottin.
No.
Honorable Senators, the results of the division are as follows. 19 senators voted for the amendment, 7 senators voted against, and no one abstained. Honorable Senators, the question is that Clause 34, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
The ayes have it. Clause 34, as amended, now stands part of the bill.
Clause 35,
Honorable Senators, the question is that Clause 35 stand part of the bill. Senator Mark, you had proposed an amendment.
Yeah, of course. I did. Yeah, Madam Chair, I noticed that the Attorney General did look at the Jamaican legislation. And I also recall when he was sitting on my side, he was very firm on this matter of an affirmative. And I'm just following in his footsteps. And I would say, Madam Chair, in the interest of justice, and because of the serious nature of this piece of legislation, that lawmakers should have an eye and should have a view via an affirmative resolution when the minister by order may by order amend the schedule. And as you know, Madam President, Madam Chair, there are several forms that we will have to deal with as we proceed to the schedules. And therefore, we are suggesting that we as a parliament should have sight of this matter and not allow it to be subject to simply the 40-day period where I can generate a resolution to have it annulled. I believe that the Parliament is making laws, and we should have sight of these laws, particularly orders to amend schedules before those things are done, and we should debate them via an affirmative resolution. It's against that background that we are supporting that the amendment be accepted and consistent with the Attorney General's own positions when he sat where I am sitting some time ago.
Attorney General.
Thank you, Madam Chair. While Senator Mark may have paid some attention to me whilst I was on the other side in opposition, I certainly never once advanced a position that forms be addressed by way of affirmative resolution, and I'll explain why. First of all, there can be no greater force of measure of subsidiary legislation or legislation which isn't contained in full parent law causing an effect than the rules created by the rules of the Supreme Court. Under the Supreme Court of Judicature Act, rules produced by the Rules Committee are subject to negative resolution. Secondly, the forms which are annexed in the schedule are the only things that are proposed to be changed. And the forms must be guided by the parent law and the springboard clauses, which, if they become law, will become sections, which guide the content of the form. Therefore, the risk of mischief crawling into a form would be hardly possible, because the forms must comply with what the parent law prescribes. So I respectfully don't agree that the forms should be amended by way of affirmative resolution, because that would be to engage the entire Parliament for the measure of amendment, which could be rather innocuous each time they have to be done. There is a balancing act in this equation, and it is the negative resolution route. We have on many occasions participated in motions of that type. And so I respectfully beg to differ with the point of view offered by Senator Mark, and to maintain that the rules instead be by negative resolution.
Honourable Senators, I will now put the amendment circulated and proposed by Senator Mark to the vote. The question is that clause 35 be amended as circulated on behalf of Senator Mark. Those in favour say aye. Aye. Those in favour say aye. Aye. Those against say no. No.
Could we have a division?
Mr. Khan?
No.
Ms. Kopi-Skoon?
No.
Mrs. Batiste-Primus?
No.
Mr. Rambarat?
No.
Mr. Sinanan?
No.
Ms. West?
No.
Dr. Henry?
No. No.
Mr. Singh? Mr. Coppin?
No.
Mr. Cummins?
No.
Mr. De Freitas?
No.
Ms. Bash?
No.
Mr. Duki?
No.
Ms. Romano?
No.
Mr. Mark?
Yes.
Mr. Solomon?
Yes.
Ms. Amin? Mr. Ramdeen?
Yes.
Mr. Sturge?
Yes.
Mr. Samuel?
Yes.
Ms. Amin?
Yes.
Dr. Mahabir?
Abstain.
Mr. Roach?
No.
Mr. Senior Constitute?
Abstain.
Ms. Raful?
Abstain.
Mr. Richards?
No.
Pastor Dottin?
No.
Senators, the results of the division are as follows. 17 members voted against the amendment. 6 voted for the amendment, and there were 4 persons abstaining. The amendment, therefore, is not accepted. Honourable Senators, the question is that clause 35 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. The ayes have it. Clause 35 now stands part of the bill.
Clause 36.
Honourable Senators, the question is that clause 36 stand part of the bill. Senator Mark, you have proposed an amendment.
Yes. Yes, Madam Chair. We believe that the regulations yes, we are proposing that in clause 36, Is the Attorney General, Madam, may I inquire, is the Attorney General deleting this clause?
No, the Attorney General has circulated an amendment as well.
Added? Did he?
Sorry?
No.
He has circulated an amendment whereby he is deleting and replacing with a new clause saying that the Rules Committee established by the Supreme Court of Judicature Act may, subject to negative resolution of Parliament, make rules for the purposes of this Act. That is the amendment that will be dealt with after yours. That is the amendment proposed by the Attorney General. Your amendment, Senator Mark, that's 36(2), is to delete the word negative and replace it with the word affirmative.
I'm very clear, Madam Chair, on that one.
Good.
Yeah, so, yeah,
Yes?
I'm suggesting, Madam Chair, that, that amendment rather be carried.
Attorney General?
Madam Chair, I admire such a stoic approach to one's position, but may I respectfully perhaps put forward a hybrid. I understand the rationale offered by my learned colleague, Senator Mark, that there be more scrutiny involved in the process. Lifting out of that submission, I would remind that the proposal for the inclusion of the minister and the negative resolution actually came from the leader of the opposition herself. I did think, bearing in mind some of the fulminations in the Senate, that we could perhaps move to a more stout position, perhaps a more improved position, by following the usual course to allow the Rules Committee, headed by the Chief Justice and the combined team of persons that sit on the Rule Committee, to come up with these and then to put it in the normal course to say that let the Rules Committee do it and let it be done by way of negative resolution, as is consistent with the Supreme Court of Judicature Act. So I do understand the proposal by my learned colleague. I think I've perhaps met him considerably along the way by the proposals which we will come to when you put mine to the floor.
Yeah, Madam Chair, because the Rules Committee is headed by the Chief Justice, I believe it is even more incumbent upon us.
Senator Mark, no, I think you're going to have to,
No.
Yeah, hold on, let me finish. That kind of comment infringes the standing orders. So Senator Mark, try and put forward your argument in a different way, please.
Well, first of all, let me put on the record, your interpretation is at odds with mine. I never meant it in the way that you have interpreted. And I have not even been allowed to complete my sentence. But anyway, Madam Chair, if you have misinterpreted my statement, I want to disabuse from your mind any aspersions. I cast none on anybody's character. So I just wanted that to be recorded. What I was simply saying, because of the importance of these rules that are being advanced, and because we understand the separation of powers principle, we believe it is important rather for the judiciary to make rules and then they come to us and we subject them to a negative resolution. We would prefer that when those rules are made, they be subject to an affirmative resolution so that we go through this exercise once and not go through it twice, because we do not want us to clash with the judiciary. We want the separation of powers to be maintained. And that is why, Madam President, we are submitting that it be done affirmatively.
Yes. Madam Chair, may I come in? Yeah. Thank you very much, Madam Chair, for recognizing me. Madam Chair, in clause 35, it states that a minister may by order subject to negative, and I agreed with that because the minister is a member of the Parliament. But as far as I'm aware, in clause 36, members of the Rules Committee are not members of Parliament. And I want to support the position of colleague Senator Mark that since they are not, all of the individuals, I am sure, are very competent. They know what they're supposed to do. But if they are to establish rules to put into effect an act to which I am a party to, I certainly would like to have sight of these rules and be given an opportunity, independently, given the separation of powers, to also debate these. And so I too would recommend to the Honorable Attorney General, simply because they are not members of Parliament, that I would like to have sight and to be given the opportunity for the whole Parliament to debate these rules, if need be.
Madam
Attorney
Chair,
General.
may I assure Senator Mahabir that the current provisions of the law provide for exactly his concern. Sight is had when it is laid. Opportunity to debate is up to you. You can move the motion to have the rules negatived. I myself have moved a motion to negative rules, so when I was in opposition. So you have exactly what concerns you.
Honorable Senator, so I will now move to deal with the amendment to clause 36 as proposed by Senator Mark. Honorable Senators, the question is that clause 36 be amended as circulated on behalf of Senator Mark. Those in favor say aye.
Aye.
Those against say no.
No. Division.
Mr. Khan?
No.
Ms. Gopi Skoon?
No.
Mrs. Batiste Primus?
No.
Mr. Sinnott?
No.
Mr. Rambarat? No. Ms. West?
No.
Dr. Henry?
No.
Mr. Singh?
No.
Mr. Coppin?
No.
Mr. Cummins?
No.
Mr. De Freitas?
No.
Ms. Bash?
No.
Mr. Duki?
No.
Ms. Romano?
No.
Mr. Mark?
Yes.
Mr. Solomon?
Yes.
Ms. Amin?
Yes. Yes.
Mr. Sturge?
Yes.
Mr. Samuel?
Yes.
Mr. Ramdeen? Dr. Mahabir?
Yes.
Mr. Roach?
No.
Senior Counsel Choate?
No.
Ms. Raful?
No.
Mr. Richards?
No.
Pastor Dottin?
Yes.
Results of the division are as follows. 18 members voted against the amendment, 8 members voted for, and no one abstained. The amendment, therefore, is not accepted. Attorney General, can we now deal with your proposed amendment?
Yes, Madam Chair. Madam Chair, the government proposes that the clause be amended by removing the reference to the minister making any rules, and instead providing for that which is normal in these circumstances of the Rules Committee making the rules subject to the negative resolution of Parliament, consistent with the Supreme Court of Judicature Act. We think that this will go some considerable way to allowing for the kind of safeguard and protection that honourable members were concerned about in the submissions made on the last proposal for recommendation by Senator Mark, which I do understand but respectfully disagree with.
I certainly appreciate your disagreement. Madam Chair, in light of what the Honorable Attorney General has advanced, and consistent with my earlier argument, may I respectfully suggest and submit that we delete in this amendment the word negative and replace it with the word affirmative. Madam?
Or you're proposing to amend?
Yes, I'm amending his
amendment.
of course, I'm amending his amendment.
I understood it constructively, Madam Chair, to mean whether I would consider amending it and then in default, a proposed amendment on it.
No, all
I understand.
amendments are subject to amendment. And I'm supporting you. You should be complimenting me.
I compliment you, Senator Mark, always.
So, Honorable Senators, what I will have to do, Senator Mark, the Attorney General has proposed an amendment. Senator Mark has proposed an amendment to the amendment. So I am going to propose the amendment to the amendment first. So I will, in the interest of clarity, read the proposed amendment of the proposed amendment. So, Honorable Senators, the question is that Clause 36 be amended as follows. The Rules Committee established by the Supreme Court of Judicature Act may, subject to affirmative resolution of Parliament, make rules for the purposes of this Act. Those in favor say aye. Aye. Those against say no.
No.
Division. Mr. Khan?
No.
Ms. Gopi
No.
Schoon?
No.
Mrs. Baptiste Primus? Mrs. Baptiste Primus?
No.
Mr. Ambarat?
No.
Mr. Sinanan?
No.
Ms. West?
No.
Dr. Henry?
No.
Mr. Singh?
No.
Mr. Coppin?
No.
Mr. Cummins?
No.
Mr. De Freitas?
No.
Ms. Bash?
No.
Mr. Duki?
No.
Ms. Romano?
No.
Mr. Mark?
Yes.
Mr. Solomon?
Yes.
Ms. Amin?
Yes.
Mr. Sturge?
Oh, yes.
Mr. Samuel?
Certainly, yes.
Mr. Ramdeen?
Yes.
Dr. Mahabir?
Yes.
Mr. Roach?
No.
Senior Constitute?
No.
Ms. Raful?
No.
Mr. Richards?
No.
Pastor Dottin?
Yes.
Senators, the results of the division are as follows. 8 members voted for the amendment, 18 members voted against it. The amendment is not accepted. Honorable Senators, the question is that Clause 36 be amended as circulated on behalf of the Attorney General. Those in favor say aye. Aye. Those against say no.
No. Division. Mr. Khan?
Yes.
Ms. Gopi Schoon?
Yes.
Mrs. Baptiste Primus?
Yes.
Mr. Ambarat?
Yes.
Mr. Sinanan?
Yes.
Ms. West?
Yes.
Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Coppin?
Yeah.
Mr. Coppin?
Yes.
Mr. Cummins?
Yes.
Mr. De Freitas?
Yes.
Ms. Bash?
Yes.
Mr. Duki?
Yes.
Ms. Romano?
Yes.
Mr. Mark?
No.
Mr. Solomon?
No.
Ms. Amin?
No.
Mr. Sturge?
No.
Mr. Samuel?
No.
Mr. Ramdeen?
No.
Dr. Mahabir?
No.
Mr. Roach?
Yes.
Senior Constitute?
Yes.
Ms. Raful?
Yes.
Mr. Richards?
Yes.
Pastor Dottin?
No.
Senator Creases.
Senator Crease?
Yes.
Results of the division, honorable senators. 19 senators voted for the amendment, 8 senators voted against, and no one abstained. Honorable senators, the question is that clause 36 as amended now stand part of the bill. Those in favor say aye. Those against say no. No. The ayes have it. Clause 36 as amended now stands part of the bill.
Clause 37.
The question is that clause 37 stand part of the bill. The question is that clause 37 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Clause 37 now stands part of the bill.
Clause 38.
The question is that clause 38 stand part of the bill. The question is that clause 38 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 38 now stands part of the bill.
Madam Chair, before you proceed to schedule.
No, I'm not proceeding to the schedule.
Oh,
just
sir.
yet.
Clause 11.
Madam Chair, sorry.
Honorable senators, this clause 11 was stood down. The question is that clause 11 stand part of the bill.
Madam Chair, should it please you, we've had an opportunity to consider the very helpful arguments and considerations offered by honorable members. We propose that we modify the language of both 11.1 and 11.2 by deleting at the end of each of those subparagraphs the words "the evidence against him" and inserting instead the following words, so that the clause 11.1 would read in total as follows. If plea discussions are initiated before charges are laid, the prosecutor shall inform the suspect of the allegations against him and provide the suspect or his attorney at law with a written summary of the relevant evidence against him, including any evidence in the possession of the prosecutor which materially weakens the case for the prosecution or assists the case for the suspect. Similarly, in subclause 2, deleting the words at the end of the subclause, "the evidence against him," the entire clause would read by an insertion of the similar words just referred to in subclause 1, but the full clause would read as follows. If a plea discussion is initiated after charges are laid, but before the prosecutor tenders evidence implicating the accused person, the prosecutor shall provide the accused person or his attorney at law with a written summary of, similarly the words, the relevant evidence against him, including any evidence in the possession of the prosecutor which materially weakens the case for the prosecution or assists the case for the accused person. We believe that that should capture the considerations offered by honorable senators. I am, however, open to further considerations.
Yes, just one sec. Just before the discussions begin, clause sub 3,
Yes, ma'am.
clause 3, are you leaving it as you had proposed, the amendment?
Just a moment. Yes, Madam Chair, and the rationale for that was that the last part read as if it was a qualification of the type of offense. So forgive me, I had omitted to look at the first version. I'm sorry. Sorry, Madam Chair, no, I don't propose on the version as circulated. I propose simply the version as just read out to you. So we're proposing an amendment to subclause 1 and subclause 2 in terms just read out, in large part coming out of Senator Choate's excellent suggestion that relevant evidence was critical and that we include the type of language which married into Part 17 of the criminal proceedings rules as well.
Okay, yes. Senator Sturge, you wanted to say something?
Yes, please, Madam President. I don't know if in the interim, since the time we stood down this clause to now, if the Attorney General consulted to understand what is the difference in treatment between the common law on disclosure and the common law on disclosure as it relates specifically to the accomplice felon. But by the amendment, I see that the words relevant and materially have been inserted. Now, the difficulty is who determines what is relevant evidence and who determines whether it materially, yes, the materiality. At common law, the general rules of disclosure, the prosecutor is the one who, on an objective appraisal of the material in his possession, will make a determination whether A, something is relevant, and B, whether it materially affects or undermines the case for the prosecution. But I was hoping that the Attorney General would have enlighten the chamber after having spoken with whoever might be considered the go-to person on this type of provision, to enlighten the chamber as to what is the distinction to be made, because as it stands, whilst the prosecutor has a discretion, and the prosecutor is the one who makes the decision on an objective appraisal of the evidence as to what is relevant and what materially affects. The prosecutor has no such discretion at common law. So we are once more placed in a position where a party who stands to benefit from the plea agreement is being called upon to make a determination on issues where he is a party and there is a party to be affected. That is why I indicated earlier, and the amendment I suggested earlier, disclose all of the evidence in his possession at that point, would bring this statute into line with what obtains at common law for the accomplice felon. So those are the two observations I have with respect to the amendments.
Senator Choate?
Thank you, Madam Chairman. Just one small thing, Honorable Attorney General. We are talking about disclosable evidence in the possession of the prosecutor. When disclosure became an issue in common law many years ago, this became a bugbear because prosecutors started saying, well, if it's not in my file or it has been sent to me, then I am not in possession of it. And sometimes very valuable material was kept away from the accused person as a result. So this is why when I had made my proposal earlier, I had proposed that we use the word the state. So if there is medical evidence, for example, at one of the hospitals, the prosecutor has a duty to get it and disclose it. So I would respectfully ask you to consider
Agreed.
changing that word.
Yes, agreed. So that we would delete the words "in the possession of the," well, so we keep the prosecutor and say the state,
Yes,
in the possession of the state.
yes.
Yes.
Thank you very much.
Madam Chair,
Yes.
Senator Sturge asked a very important question. First of all, I wish to thank Senator Sturge for bringing his expertise in this area to the forefront. Madam Chair, the only persons that we could get a hold of, really, in the context of any form of reflection on this was the Law Association. And the Law Association's specific recommendation was simply, with respect to Section 11(1), the prosecution should be required to make disclosure of the evidence that favors the defense or injures the prosecution. Nothing more and nothing less. I think that Senator Choate has taken us considerably further, and I thank the Honourable Senator for that. So unfortunately, I don't have much more of a response than that, and I'm hoping that we can take it forward at this stage with the balances that we have. I'm quite comforted that this still has to go to the attention of the court. The plea agreement coming to the court's attention under Part 4 still has to receive the court's attention, and that there would no doubt be some form of judicial attention as to the sufficiency of evidence at that point. Certainly, we are also capable of having agreements vitiated, set aside, appealed, withdrawn in a number of circumstances that we provided for. So I do think that there is enough due processing, safeguarding in this for us to settle upon a version in the terms proposed by the last circulated amendment, as further attenuated by Senator Choate's observations. So, Madam Chair, the words for insertion would be, instead of, in the two subclauses, subclause 1 and subclause 2, instead of the words reading, including any evidence in the possession of the prosecutor, we change the word prosecutor to the state. So it'll be state. Substitute the word prosecutor for state.
Yes. Okay, so Honourable Senators, the question is that Clause 11 be amended as proposed by the Attorney General as follows. In 11, subclause 1, to delete the words, the evidence against him, and substitute the following words, the relevant evidence against him, including any evidence in the possession of the state which materially weakens the case for the prosecution or assists the case for the suspect. And in subclause 2, by deleting the words, the evidence against him, and substituting the words, the relevant evidence against him, including any evidence in the possession of the state which materially weakens the case for the prosecution or assists the case for the suspect.
Accused person. Accused person, yes.
Oh, sorry, or of the accused person. Yeah, so in subclause 2.
Yes, Madam Chair, that's it.
Those in favor say aye.
Aye.
Those against say no.
Mr. Khan?
Yes.
Ms. Gopi Schoon?
Yes.
Mrs. Batiste Primus?
Yes.
Mr. Rambarat?
Yes.
Mr. Sinanan?
Yes.
Ms. West?
Yes.
Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Coppin?
Yes.
Mr. Cummins?
Yes.
Mr. De Freitas?
Yes.
Ms. Bash?
Yes.
Mr. Duki?
Yes.
Ms. Romano?
Yes.
Mr. Mark?
No.
Mr. Solomon?
No.
Ms. Amin?
No.
Mr. Sturge?
Not at all.
Mr. Samuel?
No.
Mr. Ramdeen?
No.
Dr. Mahabir?
Yes.
Mr. Roach,
Yes.
Senior Counsel Choate,
Yes.
Mr. Crease,
Yes.
Ms. Raful,
Yes.
Mr. Richards,
Yes.
Pastor Dottin,
Yes.
Honorable Senators, the results of the division are as follows. 21 members voted for the amendment, 6 members voted against the amendment. The question, therefore, is that Clause 11, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. Clause 11, as amended, now stands part of the bill. We're not going to the schedule just yet, Senator Mark.
new clause 34.
Senator Ramdeen, you have proposed a new clause in your circulated list of amendments. So let's go, you have to read it. Are you?
No, I'm
Senator
looking at,
Ramdeen?
I'm sorry, Madam Chair, I'm just looking at the way in which the Attorney General would have addressed it in the landscape version of the document provided to us. There are so many.
There was a separate sheet that we responded to Senator Mark and to you on. Senator Ramdeen, just to refresh your memory, it was the minister shall cause to be laid in both houses of Parliament annually a report on the administration
on the report.
of the Act.
Right.
And our submission in the landscape separate document, that's the 4th document, was that the JSC, the standing JSCs of the Parliament deal with these matters already.
Ramdeen, are you withdrawing your proposed amendment?
I accept the proposal of the Honorable Attorney General,
So you withdraw?
so I withdraw.
Thank you. You have to call it. Senator Mark, we are now going to the schedule.
Yeah,
But before we go, because it may perhaps assist, Madam Chair, there are some consequential amendments which the drafters have advised me are taken up as a result of what we have done in the body of the laws so far. With that said, Forms 3 to 7 would have certain consequential amendments. Yes, and what it would do in Forms 3 to 7 is to include the category appearing. One moment, Madam Chair. Where we have accused defendant in these forms, it'll now be accused defendant suspect in Form 3, wherever the words accused defendant appeared. It would instead be accused defendant suspect appearing right through, and that would also include the footers to the forms where the asterisk inclusion would happen, the reciters being placed, just the manner in which it is used. Similarly, in Form 4, again, this is consequential, taken up as a drafting style. Again, wherever accused defendant was used, it would be accused defendant suspect. Similarly, for Form 5, exactly the same. Instead of accused defendant, it would be accused defendant suspect. Form 7, exactly the same. Form 31, again, it would be accused defendant suspect. And that would be it. I'm told by the drafting team that these matters are picked up consequentially in any event, but I've just expressed it for the sake of the record.
Senator Mark, you wanted to say something?
Yes, Madam Chair, with your leave, I wanted to suggest to the Honorable Attorney General.
Just one sec.
Yes, ma'am.
Sorry. It's about the schedule, something in the schedule?
No, it is a matter dealing with an insertion after clause 38 for the Attorney General's consideration before we go to the...
A new clause?
A new clause,
Yeah.
therefore.
Just wanted them to consider.
Sure. As it pleases you, Madam Chair.
With your indulgence?
Well, could you just have the discussion and then before I put new clause and go through the formalities, perhaps you can just discuss it and then we'll see where it goes?
When you say discuss it now?
Yeah?
Yeah, thanks. Yeah, Madam Chair, through you to the Honorable Attorney General. Attorney General, I would like for you to consider reviewing this legislation. And just as how you have proposed an annual report on the administration of this law when it becomes law, I would like to suggest if you could consider an insertion to the effect that this act shall be reviewed once every 3 years, right? Through your office, and an appropriate report be tabled in the both houses of Parliament. And the reason for it, we recognize that the last piece of legislation had a lot of challenges, 99, 2017. So we don't have to wait for 18 years to go through a review to determine the challenges, the difficulties that we may have. So it would be incumbent upon the lawmakers every 3 years, given the significance of the legislation and the fact that you have really made a strong case for this being able to help in reducing the backlog. So you will want to do a review of what is happening with this legislation after a 3-year period with a view to improving areas of weaknesses and or deficiencies, and not leave it on the books for the next 10 to 15 years when a new Attorney General would have to come. And so I'm just suggesting for your consideration, if you can insert a provision for a review of the legislation. I have suggested 3 years. You might come up with maybe 2, you might say 4. But the important thing is to allow the lawmakers to review the legislation through your office. That is my submission, Madam President, to the Honorable Attorney General.
Madam Chair, I certainly understand the merit in that sort of observation. The one law that I've actually seen that prescribed in law was the Dangerous Drugs Act, never once used. Actually still sitting in the Dangerous Drugs Act. I fear that inclusion of a clause like this, whilst noble in intention, will not receive the kind of attention that it really does. And I feel that we would be better served once we've allowed the new parliamentary system to produce the work products that the Joint Select Committees are coming up with. We've only recently amended our standing orders to provide for these new standing committees which do revision of laws and drive work products. I think that we're not quite as mature as we ought to be on the role that the legislature can assist with to the executive's review of legislation. And insofar as that is still something which is ripening in the legislative experience in the Joint Select Committee work of consideration of laws and how they work, I'd prefer not to deal with that matter immediately. In any event, I don't have any policy direction on it one way or the other. So may I respectfully suggest that we defer that consideration as our parliamentary experience matures.
Madam President, Madam Chair, one final submission. I know it did not work, based on what you have said, with the Dangerous Drugs Act. Maybe because of weaknesses on the systems and the personnel. But Madam Chair, may I respectfully suggest that the Attorney General consider taking this matter to the Cabinet for a future decision so that future legislators can review legislation every 3 years as a matter of policy. And I just want to correct you on a matter. The JSCs in our Parliament, there is not a specific committee that deals with legislative review. Maybe we need to establish a committee that deals specifically with legislative review. But I really feel that as we modernize our operations, any real serious society would take into account regular reviews of their legislative framework and regime. So I ask you to take it to the cabinet, get a policy decision, and maybe the next time you will report some progress on this matter. Thank you very much, Madam Chair.
Thank you, Madam Chair. I note the recommendation. Well, just to put it on the record, as Sitting Attorney General, I have responded to reviews on legislation from a number of Joint Select Committees in the current Parliament. So it is a work product that comes out of a number of committees. Secondly, the Law Reform Commission is also a material aspect of improvement, and that is under some renovation from the Cabinet's perspective. So I'll take on board the recommendations and see if we can't find some kind of fit inside of there. I appreciate the recommendation.
So, Senator Mark, you, having had the discussions, are you still going to insist?
No, it was merely a suggestion.
Sure. All right, yes.
Schedule.
The question is that the schedule stand part of the bill. Attorney General, just to ask you, you did see that the amendments to the forms are consequential and should come naturally because of what we have done
Yes,
to
Madam
previous
Chair.
clauses, so that I don't have to put.
No, Madam Chair, no. I was just noting it out of an abundance of caution, and so noted.
All right, so the question is that the schedule now stand part of the bill. Those in favor say aye. Aye. Those against say no.
Are you going to shoot in forms one by one?
No.
Well, I think our colleagues have some concerns about the forms. So they thought when you talk about schedule, you would say Schedule 1.
No.
Or Form 1.
It's one schedule with several forms. It is up to members to indicate if there's a question about a particular form. Senator Ramdeen.
Thank you, Madam Chair. AG, I was just wondering, when we did the judge alone, there were some forms that we had used there. They were very similar to these in relation to the persons who sought to represent themselves. We had improved on them in the select committee, and I don't feel very comfortable that the forms that we have here have taken into consideration on the same basis that you recall that when we were in the select committee, we had improved on them because we wanted to include that no threats or promises had been made to those persons, whereas what you've done in these forms is simply use the broad term of being voluntary. I was wondering whether we can't improve upon it in the same way that we did in those, because the purpose of the ones that we did in the judge alone was for the identical purpose of persons who were representing themselves. If you look at Form 1A, you would see it being made plain there. And I was just wondering whether you would be so minded as to adopt the formula that we would have used in those forms.
Sure. The two forms that I looked at in reflecting, and I thank you for making the observation, was Form 4, which is the statement of the accused defendant, which appears on page 27 of the bill, and then 1A. 1A is the suspect who doesn't wish to be represented by an attorney at law. And the qualifications here is, and whereas I have voluntarily and of my free will agreed to enter into plea discussions with the prosecutor, and I have elected to have, or not elected to have, a third party of my choice, I've agreed to the plea discussions being recorded. Just permit me 1 second.
AG, perhaps I could just indicate to you.
Yeah.
There's a formula that you've used in Form 4. 1, 2, 3, 4.
No one has threatened or forced me in any way?
At line 6.
Yeah.
Perhaps if we borrow that,
Yes.
add threats in there, because there is no threat. I think these are all in the positive.
Yes. I have no objection to that, Senator
And we can
Ramdeen.
then borrow that into 1.
Yes.
And we could be consistent throughout the forms,
Sure.
so that, we achieve, I think, what you want to achieve in any event.
Okay. Okay, so if I look at it, Form 1 and Form 1A both have the two limited circumstances A and B described.
Correct.
If we lift from Form 4,
Your drafters don't have the version that we used in the judge alone here.
I'll have to just double check, do you? No, we don't have the judge alone
If we had it,
formula.
I'm just thinking that
I recall we had actually borrowed from this to do the judge alone, but what we had materially lifted was words to the following effect. Coming out of Form 4, no promises, agreements, understanding, or inducements have been made to me other than those contained. Well, that one is qualified, not necessary. But in particular, no one has threatened or forced me in any way to enter into this agreement.
Can we borrow that and put them back in 1 and 1A?
Sure. You want to give me a moment, Madam Chair, just to double check with the drafters?
In any way.
See, so see. I've had sufficient time to confer with my attorney. Madam Chair, we propose, I'm just reminding, one of the consequential amendments in Form 1 and Form 1A would be that we would be deleting paragraph B of those forms, which say, I have agreed to the plea discussions being recorded, because we've removed those in the substantive law. We are proposing to insert the words, instead of paragraph B in both Form 1 and Form 1A, I have not been threatened or forced in any way to enter into plea discussions. So, deleting what appears in paragraph B in both Form 1 and in Form 1A, and substituting instead the following words. I have not been threatened or forced in any way to enter into plea discussions. And that would ring in consonance with Form 4.
AG, you're not putting the other part about the threats?
About threats?
Yeah.
So I have not been forced or threatened in any way to enter into plea discussions. We're putting that in.
No, and the part about the promises.
That's the bit that we're looking at here now. You mean
Sorry.
no promises, agreements, understanding, or inducements have been made to me other than those contained in this
Yeah.
agreement?
Yeah. To qualify the voluntariness. You're already qualifying it in terms of no threats. So it just follows that you should qualify it in terms of no promises. They fall one into the next. You want to add it as C?
Yeah, insofar as it's a qualification of free will.
Yeah. Insofar as it's proof of voluntariness.
Yes. I've had a chance to pull up the language in the judge only,
Right.
and there was a very useful phrase here: no promise, inducement, threat, coercion, or force of any kind was employed to secure my election of this mode of trial.
Why don't we use that?
Yeah, and now the exercise would be to convert it to the first person statement as we have in A and B. So I have not been threatened or forced in
Well,
any way.
why don't you just use one each, like what you did there? I think that covers it all, both. So you can just have one A.
Yeah, I'm just looking at the language now.
Sure.
And you know, when I read the two side by side, it's properly captured in the language in the first person as stated, because it covers threat, force, coercion of any kind. It's just stated in a first person statement.
So you mean as is in the forms now?
Yeah, if I
So
come,
you
if I
take
come,
from 4 and bring it back into 1 and 1.
correct.
Sure.
So as stated in the recommended language, and thanks for the double check and caution, I think that we've captured it. I have not been threatened, forced. We can add in the word induced. So I have not been induced, threatened or forced in any way to enter into plea discussions.
Well, I have a concern,
Yes.
Attorney General, Madam Chair, through you. Particularly where and since we're dealing with 1A, which is a person who is not represented, if we put into the form language which has technical meanings, for instance, inducement, the accused not being legally trained, he is signing a document saying I have not been coerced and induced and so on. But we've taken the time in the definition section to lay out in some detail what constitutes an improper inducement. So since this person is unrepresented, should we not, and since he's before I go on, since he's simply a party to the agreement, and the prosecutor is the other party, perhaps the form must be drafted in a way to reflect that the prosecutor is also stating, I did not lead the suspect to believe that I was going to lay a charge without, and so on, or all of the matters adumbrated and enumerated from A to E in the definition section, so that it's not simply him saying I was not induced.
Understood, yeah.
Yes.
It's an excellent point. I think that we have helped ourselves out of that dilemma by providing for the court to have the supervision and reminding that we do have the Justice of the Peace certifying the matters on the page over. So I didn't want to go, because the form comes up together with the event before the court, and the court goes into matters including whether the rights were given by way of express notice and the issue of competence is to be decided, I think that we could stop with the inclusion of the words simply, instead of the two B's appearing in 1 and 1A, that we insert instead, I have not been induced, threatened, or forced in any way to enter into plea discussions.
I understand what
I know you want a concomitant obligation upon the prosecutor that he has not, in the case of an unrepresented suspect, taken the extra distance of doing something which was untoward.
Yes, and as I say that, and thank you at the same time for drawing my attention to the certification of the Justice of the Peace. Because when I look at what the Justice of the Peace has to certify, the wording of his certificate doesn't say anything to suggest that he satisfied himself that the matters which may very well impugn the integrity of this agreement were not in fact present leading up to the signing of the agreement by the accused or suspect. So that generally, when one looks at I think it's Rule 4 in Appendix B of the Judge's Rules, when a Justice of the Peace comes to certify a statement and to certify that it was given voluntarily, the learning suggests that he has to itemize. He must not simply say, I hereby certify that the following statement was given voluntarily. He has to certify that he conducted an inquiry, and the inquiry would be, I asked the accused if he was fed. He said yes. I asked him if he was deprived of sleep or if he had enough rest. He said whatever it is, and he goes through the entire list of what would of the factors which may serve to impugn the admissibility of the challenge statement, and that forms part of his certificate. But this certificate here, at page 24, I think it's the certificate that comes under Form 1A, it is extremely deficient. I don't know if my colleagues would have any suggestion, but certainly, if the JP is performing what is in essence an integral task, then one ought not to be placed in a situation where he's simply saying, this is what he's certifying
In my presence.
in my presence, XYZ. And it is not clear that when he certifies, as is the norm, when he certifies, he explains to the person, the suspect, listen, these matters, if any of these things happen to you, just tell me, because it will mean that the statement you are giving is not a voluntary statement, and therefore he writes at the end of the certificate, this is not a voluntary statement, having regard to the questions asked and the answers given. So it is really a process where the JP itemizes all of those things that would impugn the integrity of that statement.
Madam Chair.
Wants to raise something
Yes.
to the General, followed by Senator Mao.
Thank you very much, Madam Chair. Madam Chair, Form 1 and 1A again. During the deliberations in committee stage, there was agreement, and in fact there was an amendment, that individuals will have access to legal aid. That is now in the text of the bill itself. But when I read the first paragraph, I see that, and as the prosecutor has informed me as to my right to representation by an attorney at law during plea discussions, and I have informed the prosecutor of my desire to represent myself. Implicit in that is that this individual who is unrepresented has in fact consulted with an attorney, either of his own choice or one appointed for him by legal aid. But I would feel more comforted, Mr. AG, if I saw after the word myself, after consulting an attorney at law, because when we stop at the full stop myself, what it says is that the prosecutor has informed me of my right to representation during plea discussions, and I have informed the prosecutor of my desire to represent myself. But the form does not impose upon the individual this obligation to have consulted an attorney at law, either one that he has retained and fired or one that has been appointed for him. But and the issue is the individual who chooses to represent himself may very well be the individual, as we said during the discussions, most in need of legal representation. So I'm putting out for consideration for you that we simply add the word after consulting an attorney at law.
May I, Madam Chair, let me repeat what I just heard. An obligation to have the person who is unrepresented consult an attorney at law. Yes. No one can force someone to consult an attorney at law if they don't want one. If one is in the position of having the legal aid applied to the situation, then one has an attorney at law if the legal aid attorney is accepted. So it's either you're represented or you're not represented. The in-between situation at the point of saying I'll engage in a plea discussion doesn't arise. Because remember, Clause 6 says you have to have the written consent of the DPP. Clause 10 provides the circumstances for safeguards, for description of rights, etc. Clause 24 requires that the court is going to go through certain procedures to ensure that these things were observed at the plea hearing stage. So there's progress, and then we've now provided in 10 the obligation of the court to give express permission to enter into a plea discussion because you've now certified as the competence and the trawl through the various rights. So I think that we're on safe ground. I understand the observation. It's a good observation. Senator Sturges point out that the JP role under this form is not in conformity with the judge's rules is an important observation. However, what's proposed in this form is simply a form which traverses the witnessing of this event. You see, we have the newly fashioned Clause 10 specifically providing that the court must give consent for the suspect who's unrepresented to enter into a plea discussion. So we've not left it, as we had it before, for just sign the form, say you don't want to be represented, and then you progress. So with Clause 10 having the purview of competence being assessed by the court, of consent being assessed by the court, of the repertoire of rights having been recited and the judge being satisfied that the person understands that, I think that we're on a safe ground and can distinguish ourselves from the application of the judge's rules where the role of the justice of the peace is a little bit different. I should correct myself. In Form 1A, we're not deleting the reference to video recording. It is only in Form 1. So in Form 1, we're proposing that B be deleted and that we go with the formula of words proposed. And in Form 1A, we keep A and B and we insert a new C, which will repeat the same words that I just referred to in Form 1 itself, which will be, I have not been induced, threatened, or forced in any way to enter into plea discussions. Those would be the submissions, Madam Chair.
Senator Markey wanted to say something.
Madam Chair, just to follow up on what Senator Mahabir said a short while ago about inserting the after represent myself in Form A or consulting with an attorney at law, my attorney or some attorney via legal aid. Attorney General, I think under the Universal Declaration of Human Rights that we are a signatory to, and all its accompanying covenants and protocols, I think citizens of each member state is entitled, and the state has a duty to provide an attorney to those persons who are unable to represent themselves. I cannot fathom a situation where I could be party to an arrangement where, for instance, a person is saying, listen, I don't want an attorney. It just doesn't appear proper in a society, Madam Chair, where 80% of the people who commit crimes are from the poor, marginalized communities of our country. Some of them can't read, they can't write. So the point I am making...
Senator Mark, yes, that's it. I would like you to get to the point that you're making.
Yes, but the point I'm making is that I would want to insist that Form 1A be altered to include that attorney, that person would have a right to. That is mandatory.
Okay, Attorney General.
No, in addition, ma'am, in addition, that's one point.
Yes.
The other point I'd like to make, Madam Chair, is that in Form 1A, we should have provisions to deal with those persons who would need support from a third party, like, for instance, parent, juvenile, persons who are vulnerable, persons who are mentally challenged. You know, Madam President, Madam Chair, there are a number of people in Trinidad and Tobago who are under mental stress, and they're not even aware that they're mentally stressed. So the reality is that you need to put into this form provision that would safeguard the rights of those people. And therefore, I am saying that just as our Senator Sturge talked about an inquiry must be conducted by a JP, or maybe even a social worker, or even a psychiatric nurse, there must be provision in Form 1A where we add a C and a D and a E, so that when people are signing these forms, they know what they are doing, and we are giving them the best opportunity so that their rights can be safeguarded and not crushed and not be misled by anyone, Madam Chair.
Attorney
So
General.
I am asking the Attorney General to revisit Form 1A, go back to the drawing board, and come with a proper form to ensure the rights are not violated of the citizenry.
Attorney General.
Yes, Madam Chair. There's a sharp distinction between monistic approach and dualistic approach in law as it relates to international law. And I'm not prepared to rewrite the laws of Trinidad and Tobago immediately to take avail of the provisions recommended by my learned colleague, because we are purely a dualistic state. The forms as represented are in keeping with the laws of the Republic of Trinidad and Tobago, and I acknowledge the caution that my learned friend is surely pointing to, but I feel comforted that we are on the right track.
Madam,
Senator Sturge, are you raising a separate, new, different point? Because you,
Four, actually.
no, with my leave, you will seek to raise it. What I'm asking now, because we have spent quite some time on the schedule, and I have allowed several questions on different aspects. So are you raising something that is different from what was raised previously?
I'm raising four new points that only became apparent from the answer of the Attorney General and from reflecting on the forms, which I have not raised, and to raise issues which come up in the case law. So with your leave.
Yes.
Madam Chairman, the Attorney General has indicated, because suggestions were made as to who is the best person to safeguard the interest of the unrepresented person. The Attorney General has stated his position is that the justice of the peace is an adequate safeguard. But when I look at the forms, particularly the Certificate of the Justice of the Peace, it simply states that I hereby certify that the above declaration was signed by the prosecutor and the suspect in my presence on such and such a date. So he's simply signing as witnessing two other people signing something.
Correct.
That, with great respect...
Falls short of the judge's rules.
It falls short of the judge's rules, and I want to know, how is this justice of the peace acting as a safeguard if all he does is sign as witness in something which took place as a matter of fact? That's the first thing.
Sure. Madam Chair, we traversed this particular issue already. I've answered that question already.
Second thing, well, that would also take care of the equality of arms aspect. And two things from the case law. This certification, it is the certification in the judge's rules takes place in the absence of the other party, which is the police officer. So in this case, if the prosecutor is a party, should the certification of the justice of the peace, and the certification must be based on an inquiry he carries out, should it not be clear from the form that the certification takes place in the absence of the other party, which is the prosecutor, so that we can say clearly there is no coercion? And lastly, I understand what the Attorney General has said with respect to representation, but from what the case law suggests and what is the experience in court, it is our experience. People will say, as in this situation, I do not want a lawyer, and then when it comes to court, they'll say, I never said that, I wanted a lawyer, no one told me about a lawyer, and so on. And thereby, all of this would be a colossal waste of time unless the safeguards are put in up front. So I'm simply asking if we cannot put the safeguards in to prevent what is the norm in the courts, where people sign statements saying, I don't want a lawyer, and thereafter they say, look, I was forced to sign that, or I didn't sign it, and I signed a blank piece of paper, and I'm now saying I want a lawyer, and invalidate all of the work that has gone before. That's my 4 points.
Madam Chair, I understand, appreciate, and thank Senator Stewart for raising the positions that he has. We're not proposing to state now into these forms what are the judge's rules, because we're not using the judge's rules in the fashion that the judge's rules are used. We are using this simply as a justice of the peace, as an extra third party, because the accused has the right to bring a third party in, saying, I saw both of these people sign. That's it. What's happening further, so that avoids the I signed a blank paper, I didn't know what I did, because somebody else was there. Secondly, I remind that in the improved section 10, clause 10, we're specifically providing the new subparagraph C to the first, that's 10.1, 10.1c. The court has been informed of the matter set out in A and B, the traversing of all of the rights, that you wanted to represent yourself, that you signed the form, etc. The court is satisfied that the accused person is competent to enter into the plea discussion and conclude a plea agreement, and approves of the initiation of the plea discussion. So the safeguard inside of here is really the operationality of that exercise of analysis by the court as to competence, capacity, fairness, equality of arms, etc., which is why we're not really hanging our hat upon the normal operation of the judicial, of the judge's rules, forgive me. In those circumstances, we propose that the form be amended just in the limited circumstances as improved by the recommendations of Senator Ramdeen as it relates to inducement and other threat and capacity.
Honourable Senators, I shall now propose the question. The question is that the schedule be amended as follows in Form 1 by inserting a new paragraph C. In Form 1 by deleting B and inserting instead the following words. I have not been induced, threatened, or forced in any way to enter into plea discussions. And that Form 1A be amended by introducing a paragraph C to say with the words, I have not been induced, threatened, or forced in any way to enter into plea discussions. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that the schedule as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. The schedule as amended now stands part of the bill. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the Senate. Honorable Attorney General.
Thank you, Madam Chair. Madam President, I wish to report that a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto was considered in committee and was approved with amendments. I now beg to move that the Senate agree with the committee's report pursuant to Standing Order 69-1.
Honorable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto. Those in favor say aye. Aye. Those against say no.
No.
The ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto be forthwith read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto be now read a third time and passed. Those in favor say aye. Aye. Those against say no.
No. Division.
Mr. Franklin Khan?
Yes.
Mrs. Paula Gopi-School?
Yes.
Mrs. Jennifer Batiste Primus? Yes. Mr. Clarence Rambarat?
Yes.
Mr. Rohan Sinanan?
Yes.
Mr. Kazim Hussain?
Yes.
Miss Alison West? Yes. Dr. Lester Henry?
Yes.
Mr. Avinash Singh?
Yes.
Mr. W. Michael Coppin?
Yes.
Mr. Foster Cummings?
Yes.
Mr. Nigel De Freitas?
Yes.
Miss Alison Bash? Yes. Mr. Daniel Duki?
Yes.
Miss Alicia Romano? Yes. Mr. Wade Mack?
No. No.
Mr. Daniel Solomon?
No.
Miss Khadija Amin?
No.
Mr. Wayne Sturge?
No.
Mr. Roger Samuel?
No.
Mr. Gerald Ramdeen?
No.
Dr. Daneshwar Mahabir?
Yes.
Mr. Ian Roach?
Yes.
Mr. David Small?
Affirmative.
Senior Counsel Sophia Choate?
Yes.
Mr. Stephen Crease? Mr. Stephen Crease? Miss Jennifer Ruful?
Yes.
Mr. Paul Richards?
Yes. See, we affirmative.
Pastor Clive Dutton?
Yes.
23, 6,
236. No abstentions.
no abstentions.
236. No.
Madam President, the result of the division was 23-4, 6 against, and no abstentions.
22-6.
No.
Honorable Senators, the results of the division are as follows. 23 members voted for, 6 members voted against, and no one abstained. The bill has therefore been passed.
A bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto.
Honorable Senators, at this juncture, I think we will take the break. So we will suspend until 6 p.m. So this session is suspended until, sitting is suspended until 6 p.m.